on why the pervasive sexual violence during Myanmar's clearance operations indicates its genocidal intent. She will be followed by Mr. Lowenstein, who will demonstrate that Myanmar's targeting of children is also an indicator of its genocidal intent. After that, Ms. Yasmin Alamin will demonstrate that Myanmar's destruction of evidence is also an indicator of its genocidal intent. And Professor Per Dazin will conclude the morning session with a presentation on Myanmar's pervasive impunity and how that also reveals its genocidal intent. On Wednesday afternoon, Mr. Suleiman will show that Myanmar's argument that its clearance operation
(1948). You, the judges of this court, need no reminder of the horrors which preceded and precipitated the formulation and adoption of the Genocide Convention, and which led states parties Sadly, the task of 1948 remains as imperative today as it did then. But there's one aspect of the negotiating process to which I wish to draw the Court's attention. Myanmar suggests that its crimes against the committee recognized that the Convention should include as instances of genocide such crimes as group massacres, or individual executions on the grounds of race, nationality, or religion. France's delegate promoted this position, allowing that even a single death could constitute human beings today in Cox's Bazar. Pause for a moment and reflect on that number. Over 1 million people. But let us not forget that the words "in part" were explained by Mr. Rafat, who served on Egypt's delegation, as being intended to achieve the aim of the French Amendment. I turn to subsequent practice. This Court's first interpretation of the genocide of all its provisions. And so it is today. That purpose and those ideals inform the way in which the Court interprets and applies the provisions of the Conventions in this case. The Court's jurisprudence on the Convention, in particular with the Bosnia and Croatia judgments of 2007 and 2015 respectively, is the lodestar on which the Gambia's application has been based. Other aids to interpretation, including the jurisprudence of the international criminal tribunals and national courts, and it is worth mentioning that in particular it is the courts of Germany that have in recent years played the leading role in relation to findings, rulings, judgments of genocide perpetrated in northern Iraq and Syria, including against the Yazidi population. And the Gambia in these proceedings. And both parties and all the interveners agree on the basic and foundational principle articulated with force by the Court in the Bosnia judgment, that a state conflict does not preclude the crime of genocide. Second, the Convention does not require that a genocidal intent be the sole motive pursued by a respondent state or its agents, but it permits of multiple and overlapping motives. Third, a genocidal intent does not have to be expressly stated and may be established or inferred either from particular circumstances or a pattern of behaviour or conduct. And fourth, the requirement that a substantial part of the protected group is targeted does not refer to a purely quantitative criterion, but is to be interpreted in the light of quantitative, qualitative, and geographic factors. These are very important points of consensus, on the basis of which we say the Court can proceed. We turn now to the definition of genocide, the famous Article 2 of the 1948 Convention. This provides as follows. In the present Convention, genocide means any of the following acts committed with intent to destroy in whole or in part a national, ethnical, racial or religious group as such. The 5 acts that follow in the text of Article 2 are A. Killing, B. Causing serious bodily or mental harm, C. Deliberately inflicting conditions of life calculated to bring about the group's physical destruction in whole or in part, D. Imposing measures intended to prevent births, and E. Forcibly transferring children to another group. Any one of these acts committed with the requisite intent is sufficient to constitute the act and the crime of genocide. And my colleagues will take you to evidence over the course of this week which will show many acts falling within the first 4 categories of Article 2 having been committed by Myanmar against the Rohingya group. In the counter memorial, Myanmar argues that the number of victims is relevant to the determination of whether the actus reus of genocide has been committed. This is wrong. It makes this argument specifically in relation to the actus reus of killing under Article 2A, And Myanmar invites the court to conclude that unless killings are, and I quote, part of a campaign committed on a scale that is capable of bringing about the physical destruction of the relevant group or part of the group, they will be inadequate to constitute the actus reus of the crime of deliberate destruction of a human group. You can read that at paragraph 4.61 of the counter memorial. Pure invention. There is no basis in it may bear on whether there is a reasonable inference that acts were carried out with the specific intent to destroy the group. That aspect of establishing the existence of the mens rea of genocide is a point to which I will return on Wednesday, to be followed by Mr. Reichler. But two constituent elements, end of quote, to genocide, the mens rea and the actus reus. And whilst both must coexist for genocide to have been committed, they are, and I quote your words, analytically distinct. End of quote. The issue of numbers or the existence of concerted plans plays no part undoubtedly have occurred in this appalling case. It has to be underscored that the other modalities of the actus reus are just as central to the Gambia's case as acts of killing. Prominent in this case are acts falling within the scope of Article 2, paragraph B, causing serious bodily or mental harm to members of the group. Next week. I make two particular points in this regard. First, Myanmar's judgment, which endorsed the vital findings of the Rwanda Tribunal in the Akayesu case. And that case made clear that the effect of rape and sexual violence are one of the you're going to hear about this week is dreadful, and it's going to be very tough to listen to some of it. But listen to it we all must, and draw the necessary conclusions from it. We say you must. Second, forced displacement. Expulsion is recognized by the ICTY as capable of being a genocidal act. Let's be clear, expulsions do not have to result from the formal removal of people by bureaucratic state processes or the use of Auschwitz-style cattle cars. Expulsion arises in this case after the ransacking require physical force. They can, and I quote, be met through the threat of force or coercion, such as that caused by fear of violence, duress, detention, psychological oppression, or abuse of power, or taking advantage of a coercive environment. It is the absence of genuine choice that makes the displacement unlawful. End of quote. And this is exactly what has happened in the present case, along with the use of physical force, causing grave harms to the Rohingya within the meaning of Article 2, paragraph B. Such displacements may also be genocidal actus reus within the terms of Article 2C, as the court recognised in the Bosnia case. This point has also been widely recognised by international criminal tribunals in genocide cases. For example, in the Tolimir case, the Yugoslav tribunal held that underlying acts of genocide may include, and I quote, methods of destruction that do not immediately kill members of the group, but ultimately seek their physical destruction by systematically expelling members of the group from their homes. End of quote. I turn now to the second constituent element of genocide, namely the mens rea. This is a subject that has received a lot of attention, and not just from lawyers. Writers, journalists, psychiatrists, psychoanalysts, psychologists have all turned their mind as this court explained in the Bosnia judgment, and I quote, killing must be intentional, as must causing serious bodily or mental harm. Mental elements are made explicit in paragraphs C and D of Article 2 by the words deliberately and intended, quite apart from the implication of the words inflicting and imposing. The acts, in the words of the International Law Commission, are, by their very nature, conscious, intentional, or volitional acts. End of quote. And so, for the actus reus to be present, the relevant acts must have been committed with the requisite volitional mindset. In most cases, it's going to be straightforward to establish that an act is intentional, as we say it is in this case. But do so as such. Now let's turn first to the first part of this totemic chapeau, the fundamental basis of genocide, the core feature of the crime, what distinguishes it from other crimes, is that it is predicated on establishing an intention to destroy. Or race or religion. The intent must be to destroy the group as such. That requirement was explained by this court in the Bosnia judgment, some of you will know very well, as underscoring that genocide requires an intent to destroy people who share a particular group identity because of who those people are, as the court said. The words as such emphasize that intent to destroy. I'm going to address the point later today. Alongside these requirements, the chapeau to Article 2 stipulates that the intent has to be to destroy the group in whole or in part. As the court's findings in respect of context of the group overall, where other factors combine to make it substantial. As the court stated at paragraph 296 of the Bosnia judgment, substantiality is to be assessed by reference to three elements, namely, quantitative factors, commit genocide, it is necessary in the court's view to clarify the process whereby such an intent may be inferred from the individual conduct of perpetrators of the acts contemplated in Article 2. In its 2007 judgment, the court held that, and you'll see the words here on the screen, the dolus specialis, the specific intent to destroy the group in whole or in part, has to be convincingly shown by reference to particular circumstances, unless a general plan to that end can be convincingly demonstrated to exist. And for a pattern of conduct to be accepted as evidence of its existence, it would have to be such that it could only point to the existence of such intent. End of quote. Now, those are words, no doubt, we're going to be coming back to. The court can proceed on the basis of overt, that is to say, written incriminating evidence of a general plan but for understandable reasons,